Yesterday, the full courtroom went totally silent as Supreme Court Justice Brett Kavanaugh tried to find the right words. When Congresswoman Jasmine Crockett asked one devastating question during a regular judicial oversight session, it turned into a moment that legal experts are calling a turning point in constitutional responsibility. The Supreme Court justice was clearly shaken. Crockett stated quietly, "Justice Kavanaugh," handing up a document that no one thought existed. "Could you tell me why you used strict scrutiny in this case, but rational basis in a case that is almost the same?" The question hung in the air, and Kavanaugh's confident posture shifted right away. Members of the committee leaned in. The reporters stopped typing. One of the most influential judges in the United States sat in silence for a long time. What transpired next was not only embarrassing for Justice Kavanaugh, it showed that the Supreme Court's recent decisions were inconsistent, which legal experts say could change how we think about the Constitution. Hit the like button and subscribe if you're sick of watching powerful people get away with things. Jasmine Crockett's brilliant questioning didn't simply win the day. It showed a trend that could influence the Supreme Court forever. To understand why this fight has shocked lawyers all around the country, you need to know who these two people are and what they are fighting for. Since his controversial confirmation in 2018, Justice Brett Kavanaugh, 59, has been on the Supreme Court. Kavanaugh has established himself as a staunch constitutionalist by going to Yale Law School and serving on the D.C. Circuit Court of Appeals for many years. He often talks about how important it is to follow the same legal principles, no matter what your political views are. Since he joined the court, he has consistently voted for conservative issues, especially those related to religious freedom, executive power, and campaign financing. Kavanaugh often talks about the need for judges to be neutral in public and in writing. He said during a speech at Georgetown Law last year that a judge must follow the law as it is written, not how the judge wants it to be. Our judicial system is built on the consistent use of constitutional principles. This promise to be consistent is exactly what would make yesterday's exchange so special. The Congressional Judiciary Committee held an unusual hearing to look at the Supreme Court's recent decisions about the First Amendment. These kinds of hearings don't happen very often because justices usually only testify before Congress during nominations. But Kavanaugh and two other justices consented to show up, even though more and more people were worried about the court's low approval ratings and worries about its legitimacy. Congresswoman Jasmine Crockett has a different kind of legal knowledge. Before she was elected to Congress for a second term to represent Texas, Crockett was a well-known civil rights lawyer. She graduated from the University of Houston Law Center and became known for successfully fighting voter suppression legislation and defending demonstrators whose rights had been infringed. Crockett is different from many lawmakers because she has real courtroom experience. Her questioning during hearings has constantly shown that she knows a lot about constitutional law, and even her political opponents admire her for it. Before yesterday's hearing, most people didn't know that Crockett had been getting ready for this moment for months. She had carefully looked at every First Amendment case made since Kavanaugh joined the court with a group of constitutional experts from some of the best law schools in the country. Her investigation found a worrying pattern. It looked like the court was using different criteria depending on who was suing. Crockett informed a co-worker before the hearing, "The Constitution doesn't play favorites. Whether you're a company, a religious body, or a protester, the same rules should apply." The record, on the other hand, says otherwise. When Chairman Jim Jordan said that each committee member would have 5 minutes to ask questions, the stage was set. Not many people thought that Crockett's period would lead to what legal experts are now calling the most important constitutional challenge to a sitting justice in recent history. There were too many people in the hearing chamber. Some others stood against the walls, while others watched on screens in a room down the corridor that was too full to hold everyone. The mood was tense but official as Justice Kavanaugh concluded answering rather generic questions from a few senior committee members. "The gentleman from Texas, Ms. Crockett, will be recognized for 5 minutes," said the chairman. Kavanaugh moved a little, maybe because he thought he would be asked normal questions about how the court works or its overall philosophy. Crockett, who was wearing a blue suit and a little Constitution, pen on her lapel, carefully organized a few binders before looking up. "Thank you, Mr. Chairman," she said, her voice steady and clear. "Justice Kavanaugh, thank you for coming before this committee today." She started with a question that was so straightforward, it was hard to believe. "You said during your confirmation hearing in 2018 that a good judge should be an umpire, someone who is objective and fair and implements the law the same way no matter who is in front of the court. Is it still how you think about the law today?" Kavanaugh said with confidence, "Yes, Congresswoman. Following constitutional principles consistently is necessary to uphold the rule of law and the court's legitimacy." Crockett answered, "I'm glad to hear that because that's exactly what I want to talk about today." She opened the first of her binders. "I've looked over all 37 First Amendment decisions that have been decided since you joined the court. I'd like to look at how these cases have used constitutional ideas." The room got a lot quieter. This wasn't going to be a speech that pretended to be a question. It was going to be a real look into Kavanaugh's legal work. In Americans for Prosperity versus Bonter, a case decided in 2021, you joined an opinion that struck down California's requirement that charities reveal their major donors. The majority used stringent scrutiny and found that even indirect limitations on association rights deserve the strongest constitutional protection. Is that right? "Yes, that's a fair description," Kavanaugh said, seeming fine with this line of questioning. Yet just 3 months earlier, Crockett went on, in Cedar Point Nursery versus HED, you joined an opinion that put big limits on the rights of labor organizers to access, using only rational basis review, even though it was clear that it would be hard for them to do so. Could you explain why strict scrutiny is applied to donor privacy, but only minimal protection is given to worker organizing? Kavanaugh's face shifted in small ways. He said those cases were about different parts of the Constitution. "Congresswoman, Cedar Point was mostly about property rights, not free speech rights." "But Justice Kavanaugh," Crockett pushed, opening her binder to a certain page. The union clearly made First Amendment association claims in their brief on page 37. They said that organizing actions are basic associational rights that the First Amendment protects. But the majority opinion, which you agreed with, threw out these assertions with only a short paragraph of analysis. Crockett kept going without stopping. "Let me show you another case. You were part of the majority in Kennedy versus Breton School District, which upheld a football coach's freedom to pray on the field after games. The court made it clear that limits based on made-up worries about forcing students to do something were not enough. But in Fulton versus Philadelphia, which was resolved the same term, you used an entirely different criterion for Philadelphia's hypothetical worries about discrimination. Crockett put the two viewpoints quotes next to each other on a big screen that everyone in the audience could see. The contrast was quite clear. The court in Kennedy said that guessing about possible damages was not enough to limit religious expression. But in Fulton, worries that weren't based on facts were enough to keep other sorts of speech from happening. How do you make sense of these different ways of looking at the same constitutional issues? Kavanaugh moved in his chair, and it was clear that he was not comfortable. These cases are hard because they have to balance different constitutional interests. The court takes the time to think on the details of each case. "I know that every case is different," Crockett said. "But shouldn't the way we analyze things stay the same?" She flipped to a different tab in her binder. "In Americans for Prosperity, you stressed that even small violations of First Amendment rights must be looked at very closely. But in Tanzan versus Tanvir, where Muslims were put on the no-fly list for refusing to become FBI informants, which made it hard for them to follow their religion, you supported an opinion that nearly applied intermediate scrutiny." She put up another chart on the screen that showed 8 First Amendment instances with very varying results depending on who was making the claim. What constitutional principle explains why donations from businesses are more protected than religious practices by religious minorities? Or why a coach's public prayer is more protected than a protester's freedom to gather? The room where the hearing was taking place was suddenly entirely quiet. Several legal reporters were hurriedly writing down what Crockett was saying because they knew he was bringing out important inconsistencies that don't usually come up so plainly in congressional hearings. Kavanaugh, who seemed uncomfortable, tried to get back on his feet. Congresswoman, these are complicated constitutional issues that need a lot of legal knowledge and a lot of thorough study of past cases. I don't think they can be boiled down to basic comparisons. It was clear from the way he spoke that he was being condescending, and that would turn out to be a big mistake. Several members of the committee looked at each other, knowing that he was implying that Crockett didn't know enough about the law to talk about these topics. Crockett stopped for a moment, but her face didn't change. Justice Kavanaugh, before I became a member of Congress, I worked as a lawyer for 15 years, including arguing First Amendment matters in the Fifth Circuit. I know a lot about how constitutional concepts should work in real life. She kept on without raising her voice or losing her professional approach. My question isn't about different facts. The facts of each instance are different. I'm inquiring about the consistent use of constitutional principles, which you have said is very important for the rule of law. She flipped to the next page in her binder. Let me talk about a certain idea that you wrote about in your 2012 Harvard Law Review paper. You said that viewpoint discrimination is the worst thing that can happen under First Amendment law, treating speech differently depending on who is speaking or what they are saying. Kavanaugh was plainly astonished when they brought up his scholarly papers before he was confirmed. Not many members of Congress knew as much about his legal education as he did. He said carefully, "I know my article." "I'm glad," Crockett said. "I've looked at every First Amendment case that has been decided since you joined the court. You always voted to apply stringent scrutiny in issues involving religious groups, businesses, or conservative advocacy groups. But when it comes to demonstrators, labor unions, or civil rights groups making the same constitutional arguments, you've used intermediate or rational basis scrutiny in 91% of the cases." The data visualization showed up on the screen with a clear pattern in color-coded columns. The effect was quick and strong. Several members of the committee, including Republicans, leaned in with interest. Crockett went on, "This pattern goes against the viewpoint neutrality principle you wrote about in your Harvard article. It seems that the most important thing to think about when looking at the First Amendment is not what the government is trying to do, but who is speaking and what they are saying." She then showed extracts from two Kavanaugh opinions that were written just 4 months apart, side by side. You used two entirely different ways of looking at almost the same government limits on communication in these viewpoints. The only real difference was who was talking and what they were saying. Kavanaugh, clearly upset, fixed his tie. Judicial opinions are on the individual cases that are in front of the court. Congresswoman, you need to look at things differently in different situations. Crockett agreed that there are certainly different contexts, but are there also different constitutional principles? Your own writing makes it clear that the basic rules must stay the same no matter who is speaking, even if the applications are different. When Crockett opened her last binder, the fight reached its peak. "Justice Kavanaugh, I want to be very clear about the discrepancy I'm seeing in Americans for Prosperity. You said that even little constraints on association must pass strict scrutiny. That's what they said. But in Cedar Point Nursery, you were part of an opinion that used rational basis review to look at a big burden on labor organizing, which is another type of association protected by the First Amendment." She stopped for a moment before making her strongest point. The First Amendment protects more than just popular speech and prominent speakers. There isn't an exception for some points of view. The same constitutional rules should apply to everyone, whether they are a corporation, a protester, a religious group, or a labor union. When the court uses strict scrutiny to protect speech it likes, but not speech it doesn't like, it goes against the fundamental neutrality that makes judicial review possible. Kavanaugh tried to change course. The court tries to apply constitutional principles fairly. People can disagree on how to use things in certain situations. Crockett said, "Reasonable minds can certainly differ, but principles shouldn't change based on who is talking." That's what viewpoint neutrality is all about. You've written about it a lot, but your voting record on the court hasn't always shown that. Phones recorded what was clearly becoming a historic conversation. Crockett looked at one last display. She remarked, showing a split screen of decisions, In these two cases, you personally wrote that the history and tradition of the First Amendment must guide its interpretation. Used radically different historical analyses depending on who was speaking. For religious speakers, you looked at history in a very broad way. You needed specific historical examples for political demonstrators. She stared right at Kavanaugh. My question is easy. What constitutional principle allows for alternative standards of historical analysis to be used based on who is speaking or what they are saying? The room was quiet. Kavanaugh looked genuinely confused for what might have been the first time in his career as a judge. He said, "The court looks at each case on its own merits," after a few seconds. "I think my views have been in line with constitutional principles, even though the specifics may differ, Congresswoman." His answer clearly didn't address the precise contradictions that Crockett had pointed out. A few reporters were already texting furiously on their phones, knowing how important it was for a Supreme Court justice to not be able to explain obvious discrepancies in his own legal decisions. The chairman responded, "The gentleman's time is up, but the witness may briefly respond to her points." Kavanaugh got himself together. "I appreciate the Congresswoman's questions and how well she was ready for them. The court takes its duty to always follow constitutional principles very seriously. What may seem like inconsistencies are typically the result of how distinct constitutional values interact with one another in different situations." His general answer was very different from the precise patterns that Crockett had shown. The Supreme Court justice, who was recognized for his clear and comprehensive rulings, had been left speechless by precise, substantive questioning that showed flaws in his own legal reasoning. As the meeting moved on to the next questioner, cameras recorded a few high-ranking committee members walking up to Crockett with clear respect. Someone heard a veteran Republican congressman who had worked as a clerk on the D.C. Circuit comment, "That was the most substantive constitutional analysis I've seen in this committee in 15 years." The Crockett-Kavanaugh exchange had an immediate and wide-ranging effect. Videos of the fight spread quickly on social media sites. Over 25 million people saw hashtag Crockett questions and hashtag Kavanaugh contradictions in only 24 hours, making them trending topics across the country. The fact that this conversation had real substance set it apart from other viral political moments. Major news organizations stopped talking about the personal difficulties and started looking at the constitutional questions that Crockett had brought up. The Washington Post ran a front-page story called "Scrutiny Standards: The Court's Uneven Application of First Amendment Principles," which corroborated many of the patterns that Crockett had found. Legal experts from all sides of the political spectrum talked about the content of the exchange. Lawrence Tribe, a professor at Harvard Law School, tweeted, "In 50 years of constitutional law, I've rarely seen such a precise challenge to the court's First Amendment jurisprudence." Congresswoman Crockett pointed out real inconsistencies that need to be looked at closely. Even conservative lawyers agreed that her criticism was important. "I agree with many of the court's recent decisions," observed former federal judge J. Michael Luttig, "but Representative Crockett's analysis of inconsistent scrutiny standards raises valid concerns about the principled application of constitutional doctrine. Her questions were really important." CNN put together a group of First Amendment scholars who mostly agreed with Crockett's analysis. Akilah Lamar, a constitutional scholar, stated that what made this debate so effective was that she wasn't trying to make political arguments. She was pointing out real contradictions in the law using the judge's own words and ideas. The effect went beyond what was shown in the news. Law schools all throughout the country asked for permission to use film of the fight in their constitutional law classes. The Georgetown Law Center sponsored a seminar called "Scrutiny and Consistency in First Amendment Jurisprudence," which was directly inspired by the problems that Crockett had brought out. Several well-known law reviewers asked her to write special issues about the differences in scrutiny that she had pointed up. The hearing was a big professional challenge for Justice Kavanaugh. People who were watching the court said that his dismissive answer to Crockett's first queries and his failure to address her criticism in a meaningful way hurt his reputation as a Maine justice. The New York Times provided an examination of Kavanaugh's voting record that backed with what Crockett had found. He had used varied levels of examination depending on who was in front of the court. The exchange led to discussions inside the Supreme Court itself. Several justices told The New Yorker on the condition of anonymity that Crockett's analysis had pointed out significant problems with the court's recent First Amendment decisions that needed to be fixed. One insider told The New Yorker, "Some justices are really worried that this exchange showed weaknesses in the court's handling of First Amendment cases. It makes you wonder about the court's adherence to neutral principles when a member of Congress can see such apparent patterns of inconsistent scrutiny." The hearing changed Congresswoman Crockett's national profile. Law schools and bar groups want her to talk about how to read the Constitution. The American Constitution Society requested her to give a speech about impartial principles and how to read the Constitution. Major legal groups that represent a wide range of lawyers pointed to her work as proof of how important it is to have multiple perspectives in constitutional discourse. The National Bar Association set up the Jasmine Crockett Prize for law students who are very good at finding problems with constitutional doctrine. The dean of Howard Law School said in a widely read commentary that what Congresswoman Crockett showed wasn't just her own intelligence, but also the benefit of hearing from those who have really defended regular Americans in constitutional disputes. Her work as a civil rights lawyer taught her things that strictly scholarly views sometimes miss. The exchange transformed how Congress did its job of keeping an eye on the Supreme Court. Some people labeled it the Crockett model of questioning, which concentrated on legal analysis rather than political talking points or personal attacks. Other committee members started to utilize it. The confrontation may have had the most direct effect on Supreme Court law. 3 months later, during oral arguments in a big First Amendment case about protest rights, several justices, including Kavanaugh, asked questions about how the levels of scrutiny were applied to different types of speakers. Legal experts were astonished to see Kavanaugh's concurring opinion when the verdict was made. It immediately addressed the difficulties that Crockett had brought up. Even though he didn't name her, his ruling said that the court had to be careful to apply the same levels of scrutiny to all speakers and messages, no matter who they were or how popular they were. This is a basic rule of First Amendment law. 6 months after the hearing, when the court made a ruling in another First Amendment case, people saw a big change in Kavanaugh's approach. His opinion said clearly that the level of scrutiny should depend on what the government is doing, not who is speaking or what they are saying. The idea that Crockett had pushed him to accept was almost the same. The Crockett-Kavanaugh exchange became a strong metaphor for regular Americans, especially those from backgrounds that are usually not well represented in the court system, of how knowledge and preparedness can help people get above their assumptions and stereotypes. Young women of color left a lot of responses on social media that they were inspired by watching someone like Crockett hold one of the most prominent legal people in the country responsible just by knowing the Constitution. A first-year law student remarked in a viral post, "Watching Congresswoman Crockett methodically expose these contradictions showed me what's possible." She didn't yell or become upset. She basically used their own words and ideas to show how inconsistent they were. A year after the hearing, the Yale Law Journal released a full examination of how the Supreme Court used scrutiny criteria in different types of First Amendment issues. The study confirmed many of the patterns Crockett had found. It concluded that the court's inconsistent use of scrutiny standards based on speaker identity raises serious questions about its commitment to viewpoint neutrality, which is a key principle of First Amendment law. Justice Kavanaugh never publicly said how the exchange affected him, but others who observed the courts noticed a clear change in how he handled First Amendment matters. One legal scholar said Kavanaugh's recent jurisprudence shows a greater awareness of the need for principle consistency across different categories of speakers, which is a big change from his earlier opinions. This shows that he was paying more attention to consistently applying scrutiny standards. On the end, the fight turned into a case study on constitutional accountability and how important it is to stick to the same principles when interpreting the Constitution. Law schools now use it as an example of how Congress can keep an eye on things and how important it is for different levels of government to talk to each other. If this tale of knowledge winning over power inspires you, Please like this video and subscribe to our channel for more content that shows how being prepared and knowledgeable can make a big difference. Please tell us in the comments about times when someone's extensive knowledge shifted the course of a debate or argument. Your experiences help us grow our community of people who care. More about substance than style and truth than talking points.